Yeah, without further ado, let's start. So thank you again for joining. Just to give everyone a bit of background information on Class Action Capital, we were formed in 2012 by J.J. Thomas. J.J. formerly with the law firm Robbins, Geller, Rudman, and Dowd, which is one of just the largest and most successful class action law firms in the country. He also consulted for Garden City Group, which is a very respected and established class action settlement administration company. The rest of us, we have various backgrounds in sales, marketing, legal, and finance. Our specialty is the research, data collection, analysis, and filing of these complex class action settlement claims. Our goal is to really maximize your recovery and limit the amount of time and internal resources you would spend on this. While this information is publicly available, the difficulty for our clients and claimants is really knowing which settlements are applicable and what data will be needed by the court administrator. By working with us, clients do not need to sift through any invoices or purchase records. We utilize data models and formulas when submitting your claim to the court administrator, and in the majority of the settlements we work on, we are not going to ask for any supporting documentation, purchase information, credit card receipts, etc. We work on a contingency fee basis, so there's no upfront cost, no filing charges, really no financial exposure to your facility at any point in time. At the point we get involved and submit claims, this process is purely administrative. Your facilities are not getting involved in any of the litigation. The process is completely confidential. And we currently work with over 5,000 corporate clients, approximately 1,000 of whom are hospitals or healthcare facilities. So today I'll be touching upon information on 5 settlements, but focusing on the payment card interchange fee class action settlement as well. The first settlement, just to make everybody aware, this is a lithium-ion battery settlement. So this is $106 million, which stems from antitrust violations. It'll reimburse companies who indirectly purchased lithium-ion battery products between January 2000 through May 2011. And lithium-ion battery products include a significant number of portable electronic devices, inclusive of laptop computers, notebook computers, tablets, iPads, mobile phones, smartphones, digital audio, digital video recorders, power tools, walkie-talkies. Most likely anything with a rechargeable battery is eligible. And to submit a claim in this settlement, we will not require any invoices, purchase history data. We are using an administrator approved data model that we've modified just to calculate refunds. We would only need a current employee count and a current hospital bed count. The deadline to file a claim with this settlement is January 19th, 2019. The next settlement that's applicable is the blood reagents settlement. So blood reagents, for those who are unaware, they're designed and manufactured to test, match, detect, really just identify certain properties of the cell and serum components of human blood. Traditional blood reagents are primarily used to test manually in test tubes, and then just in contrast, proprietary blood reagents are used to test in automated or semi-automated platforms. This is a $41.5 million settlement, and it would resolve allegations that the defendants violated federal law by manipulating the price of those traditional blood reagents. The eligibility period is November 4th, 2000 through October 19th, 2015. And both defendants have settled, but there's no filing deadline just yet. The cathode ray tube settlement or CRT. These are vacuum tubes that were primarily used to display images in televisions or computer monitors. This technology is the precursor to flat screen, plasma, and LCD technology. I'm sure everyone remembers having a big bulky computer or television in your home or office, and your facility is likely eligible for a refund if it indirectly purchased a CRT product between March 1995 through November 2007. And as this was the dominant technology at the time, it's very likely that all your facilities are eligible. And just to clarify by what I mean with indirectly, so that just means that this product or these products were purchased from someone other than the defendants, most likely through a retail store or a distribution channel. No filing deadline yet, but we've been told that settlement payments are projected to begin in next year. The optical disk drive settlement is $205 million. It resolves allegations that the defendants conspired to fix the price of optical disk drives, which are DVD-RW, DVD-ROM, combo drives. Most likely, you'll know them as the CD-ROM drive that's in your computer. Your facility is eligible if it purchased these products as part of a computer or a standalone external drive anytime between April 2003 and December 2008. Similar to the lithium-ion battery settlement, or I did not mention this, but similar to the lithium-ion battery settlement, the defendants in the optical disk drive settlement control such a large market share of the industry that even if you're unclear that you had purchased a product from these defendants, either directly or indirectly, your facility is still likely eligible based on the fact that how much of this alleged collusion affected other industry members and how much of a market share that these defendants control. We will not require any invoice data or purchase records. Again, just a current employee count and a bed count. And then just bringing us to the main event today. So this is the payment card class action settlement. I'm sure you're all familiar with this as it has been around for a number of years. And for those of you who are not familiar with it, this settlement will resolve allegations that Visa, MasterCard, their issuing banks had violated the law by setting excessive interchange fees and then placed or put rules in place that prohibited merchants from accepting other forms of payment from customers which might have been less expensive or charging excessive fees for certain types of reward cards, cashback cards, etc. Your facility is very likely eligible for a refund if you accepted Visa or MasterCard, credit or debit cards anytime between January 2004 and today. The settlement was actually just there was a preliminary approval hearing last week where the judge did indicate she would grant preliminary approval on the settlement. I don't know if that ruling has been filed, but we anticipate it happening either by the end of this week or beginning of next week. That would start the next, I guess, phase of the process, which is an opt-out period, as well as the time frame for the final approval hearing. Most likely will be 6 months from now. This settlement fund is going to be no less than $5.5 billion, but it could be up to $6.25 billion, depending on the number of companies who do opt out. No official claim form, no filing deadline yet. We are anticipating probably a September 2019 start to the claims filing process. This settlement most likely will be another 18 to 24 months before it does pay out. So I would say at a minimum, we're probably looking at 2021 before this settlement does start distributing funds. It is unclear whether or not Visa and or MasterCard are going to be presenting their data or submitting their data to the court administrator. We believe, just based on a previous filing that was remanded back to the court in 2016, that Visa is going to provide information. So we would not require any of your merchant service statements, any credit card receipts. We can utilize the information that was provided by Visa to extrapolate information, aggregate information for you, and really take all the heavy lifting off of your hands to make sure that this is as seamless and painless a process as possible. I'll say that while no one needs to sign up with a third-party service such as class action capital in order to participate in any settlement, the difficulty is really understanding what data, if any, is going to be provided by the defendants, how that would apply to your facility, as well as what additional information may be provided just to ensure a complete claim. And just a reminder, our fee, again, contingency based, no upfront cost, no filing charges, and the process is completely confidential. For those of you who are interested, next steps would be to complete a authorization form at the website listed on the screen. I'll also email this out to everyone who's attending today as well, where you can review the information that I shared on the other settlements and the payment card settlement. And please feel free to call or email me directly with any additional questions on anything discussed, or if I didn't touch upon a certain topic you're curious about. This is my direct contact information. Please, again, feel free to email, call. Very happy to speak to everybody. I know I threw a lot out at everybody. I will pause if anyone has specific questions on any of the settlements discussed.